Appellate Division 4th Department. Hear ye, hear ye, hear ye. All those that have business before this court will draw near, give the attendance and shall be heard.
Good morning, please be seated. I believe that they are present. I'd like to welcome the students for the EMDH Charter School who are here today and are going to be listening to some of the oral arguments. Are you present? Great. First case for oral argument this morning is 857, People versus Mario Turner. And so the students understand that we also do some of this remotely, and so we're waiting for the person to come up on the screen. Good morning. Go ahead, Mr. Kemp. You have to unmute yourself. You have to unmute. Yeah, very good. Thanks.
There we go. Sorry, Your Honors. Good morning, Your Honors. Robert Kemp on behalf of Mario Turner. Based upon the evidence submitted at trial, the jury incorrectly determined that the facts and testimony supported the requisite element of intent necessary for the conviction of murder in the second degree.
Okay, so Mr. Kemp, can recklessness be inferred from the totality of the circumstances here?
Yes, it could. He never denied accidentally shooting Mr. Shadow, but he just said it was an accident. So there was definitely recklessness involved that qualified under manslaughter in the second degree. The jury should have realized that intent was not proved by the people, and this should have been recklessness and should have been a conviction of manslaughter in the second degree.
Why don't we look at some of those circumstances? He was enraged. Okay, he actually broke the victim's phone right before they struggled with a gun, and he was the one who got the gun. It was his gun. He got it out. So all of the steps towards this incident happening were precipitated by defendant.
That's correct, Your Honor. He never denied accidentally shooting Mr. Shadow. He actually got the gun. He said he testified on his own behalf and said he found it underneath his son's bedroom. It was already, I guess, a shortened shotgun. There was tape over the safety indicator. A firearms expert testified that there was tape over the safety indicator, which means nobody would know if the safety was on or off. He testified that he's not familiar with guns, not familiar with gun safety, never fired this gun before. And he testified about a prior incident where he racked the gun, which put a live bullet in the chamber and didn't unrack it. So it remained racked with a live bullet in the chamber, and unfortunately until the night of this incident. And then testified that he did confront his wife about her ongoing infidelity, that he was upset. He testified he was upset. He's been with Ms. Teixeira for 29 years. He was upset that she was once again having an affair, but he testified that he just wanted to know who this man was. And also the daughter also testified, Jasmine Turner, that her father wanted to know who this man was. And she even wrote a note after this incident saying that Mr. Turner was not really was upset, but wasn't really mad at Ms. Teixeira, but wanted to know who this man was. And unfortunately, there was a struggle in the bathroom and the gun went off. I mean, there was also a forensic biologist from the Central Police Services lab that testified, she testified about the DNA on the handgun and testified concerning DNA of both Mario Turner and Renee Teixeira, and discovered that Renee Teixeira's DNA could not be excluded from the DNA that was found on both the front and the back of this handgun. And there was testimony actually from Jasmine Turner and Shaquille Young that they never observed her handling this shotgun before. So that just proves that there was a struggle in the bathroom and it just accidentally went off. Now, with respect to the challenges for cause, the defense counsel was obviously concerned about several juries that were excused for challenge for cause, especially juror number 13, who made some statements regarding his personal opinion of gun safety. I mean, he stated that you would never point at something you don't intend to destroy, and that guns don't go off don't go off negligent, but not accidentally. So this was definitely an opinion. This was definitely a serious doubt regarding his impartiality to view this evidence.
And counsel, you didn't think that the court rehabilitated him enough to have him sit as a juror?
No, the court didn't go far. Neither the court nor the ADA went far enough to rehabilitate him. There were still some serious questions regarding their impartiality, and that goes with also the court did not go far enough with respect to jurors 7 and 17 with respect to putting their emotions inside and looking at the facts and the evidence of the case rather than getting emotions involved.
We'll look at that very carefully.
That also goes to the Molyneux. If I can just briefly talk about the Molyneux too. I know background information and prior acts are allowed in domestic violence situations, but the issues that Jasmine Turner and Shaquille Young talked about definitely some prejudice involved here. Definitely should not have been submitted to the jury. This created a propensity that Mr. Turner had issues with domestic violence and violence toward Ms. Shetta and should not have been allowed towards the jury. He never denied accidentally shooting Ms. Shetta, but only said this was an accident.
Okay, thank you.
Counsel, why don't you address that last question first, the Molyneux? Why was that permissible in your view?
Domestic violence does not occur in a vacuum. At times it occurs with a series of events that precede the crime. Here, these events were particularly applicable to show the defendant's intent, the absence of a mistake or accident, and to give context to a domestic violence situation. There was significant probative value to this Molyneux evidence, and when compared to the prejudice, and there's always risk of prejudice to the defendant, the court in its sound discretion limited the number of Molyneux items only to those that immediately occurred in the months preceding the crime. Just going to the point, though, in terms of, we heard about the defendant's reasons and the defendant's theory, but when looking at legal sufficiency, it's in the light most favorable to the people. And here, the defendant's conduct, in addition to the Molyneux evidence, the defendant's conduct and the circumstances surrounding the crime showed that he shot the victim, he went to grab the gun, cornered her, shot the victim, ran out of the house, and immediately admitted to a family member and a friend that he shot the victim, never mentioned it was an accident. So I think there was sufficient evidence here on the issue of intent.
He also never did anything to try to help her after being shot.
Never called 911, never called ambulance, never offered any assistance. That's correct, Your Honor. Leading into I'd like to next address the challenge for cause and the jurors. And it really,
Start with juror number 13.
Juror number 13.
You said you never point something that you don't intend to destroy.
Okay, well, that was in the context, first off, when you look at the jurors' statements, you have to look at it in the totality of the voir dire record. That was in the context of when he was talking about being trained as a boy by his parents. He's not using this gun for protection. He's using it as a hobby to shoot at clay targets from time to time. He was saying, in essence, when his parents told him that, they were basically telling him, as any parent would do, be careful with the gun. Now, at another context, he says that the gun was pointed to kill the victim. He insinuates that. And I want to address that because, again, it looks to the context of the voir dire record. And Justice Greenwood, you were on the panel that decided People versus Saley in August, which in that decision talks about the context of the voir dire record. And here, when immediately preceding that statement by the juror, defense counsel had a long colloquy talking about intentional acts that don't result in intentional results. When you're talking about an intentional act, the juror took it as meaning that the defendant must have intended to commit this crime. In fact, he stated, apparently it ended up. He could only say that if he's making reference to the earlier statements by defense counsel. He also further stated, as pointed out in People v. Saley being an important consideration, is that he acknowledged, I don't know all the facts, and he was able to judge intent and follow the scientific evidence. So when you look at it in terms of the totality of the voir dire record, it never raised to a level of serious doubt in terms of being fair and impartial. And again, it's serious doubt, not mere, not possible, not just doubt.
We definitely understand that, okay.
All right. And unless there's any other questions, I'll rest on the remainder of my arguments.
Thank you.
Thank you.
558, People versus Clifford Hunt. Apparently, Ms. Field is not here today.
I have received communication from her, Your Honor, in which she indicated that she was ill and would not be able to
Oh,
appear.
I'm sorry, okay.
So in light of that, I'd be happy to rest upon my brief unless there are any specific questions from the court.
Thank you.
Thank you.
860, People versus Ryan Reeder.
Good morning, Your Honor. I'm Charles Greenberg representing Ryan Reeder in his conviction from Ontario County for criminal sale of a controlled substance in the third degree, which was rendered on June 11th, 2019. In reviewing my brief and going through all 4 points that I made, I like to argue point 1 and point 2 kind of simultaneously because the issue, one of the concerns that I had with ineffective assistance of counsel was the failure to ask for an instruction concerning criminal possession in the 7th degree, because that also dovetails back to the first argument where agency and weight of the evidence was considered. And the reason why I point that out is because agency is not a full defense to to the indictment as in principle, because that only eliminates the idea that he sold a drug. And my client has been very adamant in his correspondence with me is that he was strictly an agent. Ms. Serrano was the confidential informant. She was the one that initiated the sale. He didn't select where the sale was going to take place. I believe this particular sale that's in controversy here took place at a Wegmans in Canandaigua, not inside the store, in the parking lot. And that he didn't promote the sale. He didn't tout the drugs or anything of the sort. But I mean, if the court adopts that theory here, that of course reduces the element of the sale. But of course, you could still arguably still possess the drugs. But so the failure for Mr. Gilmore to raise that, to ask for that instruction, could be construed as ineffective assistance of counsel.
Okay, we'll look at that.
And my client also, I pointed out in the reply brief, is that he also wanted the instruction for agency to the grand jury, and that should also cause the indictment to be dismissed. Is there any other comments?
Thank you.
Thank you.
Ms. Porter?
Morning, Your Honors. Caitlin Porter on behalf of the people. The jury here was charged with agency. They rejected it as a defense. I believe there's more than enough evidence in the record to support that rejection. As for defense counsel's argument today, I would just submit to the court that agency does not reduce a sale charge to a possession charge. As cited in my brief, the Court of Appeals case is People v. Davis, that agency doesn't reduce to that charge because it's possible to sell drugs without possessing them at the same time. And as for the arguments that are raised for the first time in defendant's reply brief, I'll also ask the court to reject those concerning the sufficiency of the minutes of the grand jury transcript, as well as the prosecutor's instruction in grand jury. Those are raised for the first time in the reply brief, and I'll ask the court to reject them. Unless there are any further questions, I'll rest on my papers.
Thank you. 861, People versus Michael Lavelle.
morning. May it please the court. Donald Thompson on behalf of Mr. Lavelle. In this case, the proof was legally insufficient to sustain the conviction for manslaughter in the second degree. Failed to prove recklessness. It's a good contrast, I think, with the first case on the calendar this morning where Justice Bannister was ticking down the actions of the defendant that would tend to support reckless conduct, that would tend to support choices that resulted in the outcome, not simply an accident. I mean, this court's case in Lash is probably the best example where the court said, just crossing over the center line is not sufficient. There has to be something else. It has to be more than an accident. And
Counsel, your position is bad driving is not recklessness.
that's right, Judge.
Right.
It was an accident.
Other than the testimony of the passengers in the Mercedes, what evidence in the record is there that your client acted recklessly?
I don't contend that he acted recklessly.
Right.
I mean, I don't contend.
That's your point. There's video evidence.
Right. I mean, there's the black box evidence from his vehicle, which demonstrates that he's in the lane. By all accounts, he's not intoxicated. He was given a breathalyzer, 0.0. He's not swerving. There's no credible evidence that he's yelling or engaging with the other vehicle.
And he was very cooperative afterwards.
Very cooperative. I mean, the court has had the opportunity to review the interrogations, not really even interrogations in the hospital of Mr. Lavelle, where he invites the officers to ask him more questions, and I think if you view the videos, is legitimately in shock at that point, but is trying to assist the officers in figuring out exactly what happened here because he doesn't know. I mean, significantly.
He says he didn't remember.
Right.
And then so the testimony's all over the place in this case, right? The drivers in the SUV, the husband and or I don't remember
right.
Their husband and wife, or I think they were. And they disagree on the testimony about where his vehicle, whether he passed on the right or whether he passed on the left.
Right. Their testimony is simply not credible, Your Honor. If you
Even
look at
they go so far as to say that he was right up on them, and then if you view the cams that were out there, he wasn't. He
right,
was
I mean,
like 3 or 4 cars back.
Exactly. They claim he's tailgating. If you look at the camera, you could comfortably fit 4 vehicles between his vehicle and the SUV. They claim that he is tracking them around the left-hand turn that they make off of Calkins Road, which is demonstrably untrue, given the black box evidence, given the video evidence from the dash cam of the car that is behind. They say he's an inch from their vehicle. Again, demonstrably untrue. That goes to our weight of credible evidence point. All of their testimony, but for their testimony of their own actions, throwing him the finger twice. The husband, who's in the passenger side, yells at Mr. Lavelle as he's passing, apparently, which the husband, the passenger in the SUV says, leads him to turn his head. Well, when he turns his head, that's about the 1.5 seconds when he drifts over the center line. Because as we learn in motorcycle safety class, where you look, there your vehicle goes. And I contend that that's exactly what happened here.
Now, the lower court precluded your expert from opining on distances, is that correct? Or instructed the jury not to consider that testimony?
Well, that's kind of interesting, Judge, because there was no disagreement. In fact, they agreed consistently, the prosecution expert and the defense expert, on the black box information that winds up being the substance of that testimony, as well as Exhibit G, which was admitted prior to that preclusion motion. And the defense specifically asks about Exhibit G because of that preclusion motion and says, is that exhibit still in good standing? And the judge says, yeah, I didn't unadmit the exhibit. So it's all of the content is still before the jury. And in fact, the prosecution uses it when they're going through both cross-examining the defense expert and on closing. It tracks where Mr. Lavalle's vehicle is. It shows that he remains within the lane, that he's not speeding. He's actually 13 miles an hour under the speed limit. And there's no disagreement between the experts on that. So, the lower court kind of jumps immediately to the most significant sanction which, without a finding as required in the CPL in Section 2, Article 245, that there was some bad faith on the part of the defense, that they were trying to gain some advantage by failing to disclose this. As a matter of fact, the prosecution had all the conclusions before they had these calculations. And when they got the calculations, what did they do? They didn't ask for an adjournment to review it with their expert. They didn't ask for time to do anything else. They just continued on with the cross-examination as if basically nothing had ever happened. There was no demonstration of prejudice. Thank you, Judge. I think the only other thing I'd just like to touch on briefly, if I could, is just, and I will be brief, is the jury instruction that was provided on blameworthiness, or the failure to include blameworthiness as essentially an element of manslaughter in the second degree. And here, it's a little bit different case because the defense specifically requested it based upon the Court of Appeals case law. And as you know, blameworthiness is incorporated in the criminally negligent homicide instruction. So it can't be not part of manslaughter in the second degree. It has to be, because it's a lesser included offense. We know, although Green Glover, as the jurors, didn't, but they don't get to consider blameworthiness, and it really makes it sound like manslaughter in the second degree is easier to prove than criminally negligent homicide. Thank you, Judge.
Thank you. So, Kathy.
Good morning, Your Honors. I'm Marty McCarthy for the people. Yes, a simple traffic infraction will not support a conviction for either manslaughter in the second degree or criminally negligent homicide. Just like simply not seeing what there is to be seen will not support a conviction for a criminally negligent homicide or manslaughter in the second degree. But however, we had both in this case. The defendant said he never saw the motorcycle when he was asked about that. And we also have him not only crossing the line, but also there were other assorted vehicle and traffic violations with respect to his conduct. And when you look at his conduct, it's not just crossing the center line. It's not just not seeing what there is to be seen. He didn't see what there was to be seen because he was so focused on what was going on in the vehicle in front of him. And you look at the testimony, and I will concede that the Congelaro's testimony was a bit it was a bit all over the place, if you will. But when you look at the video, at the end of the encounter of this between these two vehicles, these vehicles are extremely close to each other. When the Congelaro vehicle turns left, the defendant's vehicle is almost entirely upon that vehicle.
Isn't that what happened when people turn left? You know, the car that's driving straight through, they kind of catch up because you got to slow down and turn left. I mean, we've seen the video. It looked like an ordinary turn to me, and simply that the defendant's car caught up to the slowing car who was going to make a left-hand turn. I agree, they got a little closer.
Now, typically in that scenario, I mean, you all drove here today and drive in your daily lives. When you see a vehicle turning left, you typically go to the right to go around it in case that vehicle doesn't complete its turn. It didn't happen. If that vehicle hadn't completed its turn, there would have been a collision because the defendant was following too close at that point, right? So as that vehicle's turning, the defendant takes his eyes off the road and he starts engaging and yelling and swearing at the people in that vehicle. Now, you ask...
Just a moment. What proof is there that the defendant was yelling and screaming?
That proof came from the occupants of the other
Right,
vehicle.
who you just said, their testimony is a little iffy.
Well,
and they testified that they flipped the defendant off.
Yeah.
And yelled at him.
They did. And that doesn't make them angels in this scenario, unfortunately.
Well, I understand that, but I'm struggling to find proof of recklessness here. Because you talked about some additional vehicle and traffic law infraction. He wasn't charged with violating, he wasn't charged with speeding, he wasn't charged with getting out of the lane.
No, but he wouldn't.
And in fact, the testimony was that he passed on the shoulder of the road, and the video indicates he didn't.
I'm sorry?
The testimony from the drivers in the Mercedes was that he tried to pass them on the right side of the road on the shoulder.
Mm-hmm.
That's belied by the video.
By the video behind them, yes.
Yes.
So in that sense, that was a failure of perception.
Right.
Yeah.
Right.
But again, you're talking about what they're perceiving, and if they perceive that incorrectly, the
But
jury...
we're looking at proof. There's no proof of speeding, right?
No proof of speeding.
There's no proof of intoxication,
No proof of intoxication.
and there's no proof of erratic driving, other than this moment where you say you approached the car as it was starting to turn left.
Well, when you look at the when you talk about erratic driving, you have to look at the end result, right? Here, the vehicle doesn't just drift. That's the other issue in this case. This was not a drift. This was a hard turn to the left.
I'm not sure that's what I saw on there. I didn't see a turn. I didn't see the tires go that way. I sort of saw the car just drift into the other lane, like almost unconsciously, not purposefully.
When you look at the black box data, in order to accomplish the manner in which he went from driving straight to that, I guess you would call it 11 o'clock position on a clock, as to where that vehicle started to enter the other lane.
Sorry, I was looking at the clock to see what the 11 o'clock
11
was.
to-
I wasn't just looking away from the camera.
When you look at that, though, in order to accomplish that, that required a hard steering input, and that was brought out through the black box data. That was not simply, you're kind of, the wheel's kind of just doing this. Like this wheel went from this to about that.
We've
That took a
watched
lot.
it, and we'll look at it all very carefully.
Yes.
Mr. McCarthy.
Are there any other questions?
Thank you.
Okay.
Thank you. 862, in the matter of Barry G. Oh, this is remote. Good morning. Good morning.
Good morning, Your Honors.
Waiting for one more person. Great. Thank you. Go ahead.
Thank you. May it please the court. Caitlin Connolly for the respondent appellant father. Your Honors, there are just a few things I would like to point out today. As to the incident of June 1st, the father testified that this was the result of emergency circumstances which left him stranded in Niagara Falls with no ability to communicate and no transportation. The department returned the child to the father's care less than 2 months later, apparently satisfied at that point that he was an acceptable guardian. As to the incident of August 2nd, this presents a credibility issue. The father testified that he left his son outside playing with friends for a few minutes when he went to the store to get the child a drink, which conflicts with the caseworker's testimony that he left the child for 20 minutes. My client loves his son very much. We are grateful to the court's attention to this matter. Unless the court has any questions, I'll rely on the brief.
Thank you.
Thank you, Your Honor.
Go ahead.
Good morning, Your Honors. Gabriella Gannon on behalf of the Erie County Department of Social Services. Your Honors, the department believes it is clear based on the record before you that there's a sound and substantial basis for the trial court to find neglect as a result of the respondent appellant's failure to provide proper supervision and failure to make a reasonable plan to ensure the safety of his son. As counsel mentioned, on June 1st, emergency circumstances left the respondent appellant stranded in Niagara Falls. This was on their last day residing in a shelter, and the respondent appellant did not contact to ascertain the whereabouts of his son or try to get into contact with him or ask for any emergency services to reunite him.
Counsel, it wasn't just an hour or two, right? This was 3 days.
Yes, it was 3 days, and he completely left his son, did not contact emergency services to try and reunite him with his son.
Right, and the son had no food or anything.
Nothing, and his son was 8 years old at the time. He is diagnosed with autism and ADHD. And he reported when the department was called that he reported to the caseworker who arrived that he was scared for himself and his father. I understand
Counsel, let me ask you another question, okay? I believe there is some reference, maybe in the briefs, that there was a subsequent permanent neglect proceeding. Is that so, and do you have any information about that?
Unfortunately, I do not have any information about that.
All right.
Anything further?
I would just like to point out that the child was returned to his father at some point under strict conditions that the father or respondent appellant would not leave his son unsupervised under any circumstances based on the history and the fact that he had left him for 3 days. And he did admit, through testimony that he did leave his son for an undisclosed disputed period of time. So unless there are any further questions, I will rest on my papers as well.
Thank you.
Good morning, may it please the court. My name is Jennifer McCann. I am an attorney at the Legal Aid Bureau of Buffalo, and I'm the attorney for the child at this time. My client was abandoned for 4 days. That's what it comes down to. Not at any place other than a shelter unsupervised with strangers. Because let's be honest, we don't know who is coming in and out of a shelter and if they're safe for children. This was not an appropriate person or an appropriate in my position situation. My client was scared and honestly remains scared at this time. Otherwise, I'm going to rest on my papers, but I'm open to any questions from the court.
Thank you. 863, Deere versus Winslow. Did I come anywhere close pronouncing that correctly?
I'm sorry, I was late to the party, Judge. Dave Pajak for appellant. It seems to me that if Ms. Deere's trial attorney had been put on notice that the judge was going to treat the motion on the pleadings as the motion for summary judgment, he would have responded with proof. Instead, he responded with a brief, which is what you should do in response to a motion on the pleadings. He didn't submit any proof, and the judge granted the summary judgment motion, which was actually a motion on the pleadings, despite the fact that Dr. Winslow had never submitted an answer, never submitted a denial in person, but only submitted papers through his counsel. I don't think that summary judgment was properly granted in this case. I think notice is required under the Court of Appeals case Bello versus Orofino Realty, which is on page 28 of the brief. If there are any questions, I'd be glad to address them now.
Thank you very much.
Thank you.
Good morning, Your Honors. David Abatoy for Raymond Winslow. I'd first like to start by responding to my opponent's suggestion that this was a motion for summary judgment. There was indeed no indication this would be treated as a motion for summary judgment because there was no need to do that. This was very clearly characterized in the lower court as a motion under 3211 invoking the doctrine of res judicata and spreading on the record all of the prior proceedings and the documents from these prior proceedings. In that light, it was perfectly acceptable for the lower court to consider all of the prior allegations that had been made and the documents that address those allegations. So there's nothing sort of out of the ordinary or done without notice for the petitioner here because she clearly was able to review the basis for the motion and the papers in support of it. It wasn't a motion for summary judgment. The reason why those prior allegations are important are precisely because the petitioner herself invoked all those prior proceedings and actions as the basis for her current allegations. She claims that this circumstantial evidence that she has in prior proceedings should be reviewed and effectively creates a reasonable inference in support of her present allegations. Well, they don't. We've seen her prior allegations. We've seen that they've been rejected by the Maryland court, by every other court and body that has addressed them. And we've also seen that the basis for her allegations is her strange belief that Dr. Winslow, as a person with a federal grant, is permitted to hack into people's computers and steal information from them. That is the basis that the petitioner asks this court and the lower court to accept as a fair inference that Dr. Winslow is the person that hacked in her computer. Somebody did that at all. The things that she describes also sound like computer malfunctions that could perhaps be accidentally caused on a person's own computer or in numerous other ways. The only evidence she has, and she even says so in her brief to this court, unless we can point to somebody else who has computer expertise to do this kind of thing, it must be Dr. Winslow. I laid out case law in my brief that says that really is not inference, that's asking this court to engage in speculation. She admits in the lower court, I think, that she doesn't really know that Dr. Winslow is the source of this, that she needs discovery to come up with the IP addresses and what have you. In this case, it's a little bit different than most in that, it's a family offense type petition, but this is kind of a whodunit at the outset. She has to establish why she thinks Dr. Winslow is the perpetrator
We'll look at
here.
that.
Thank you, Your Honor. I appreciate your time. Thank you.
Thank you. 867, Badalaro versus Ames. Oh, okay. I'm sorry, first you need to unmute, and I thought you were going to be, oh no, here you go. Okay, can you unmute yourself? Perfect.
I apologize. Thank you. Catherine Hartnett for respondent Sandra Vettalaro. In light of the fact that appellant has submitted, I will also submit unless the court has any questions they'd like me to address.
Thank you.
Thank you, Your Honor.
Good morning, may it please the court. I just want to point out, and it's obviously clear from the record, when the trial in this matter started, my client was 6 years old. He's now 10 and a half years old. That's a lifetime. He's a totally different young boy. That said, go ahead. I can see you're going to ask. As of last week, the last time my client saw his father was on Christmas. The father does not call him. The last time he spoke to him was on his birthday at my client's. My client called him on his own birthday. So that said, I only raise that to point out that the trial court is in the best position to view the sincerity and credibility of these parties.
And it's been 4 years that he has been in his mother's soul.
Yes.
Is that correct?
Yes. And little to no contact. So we would just ask the court to affirm the decision and let this family move forward in whatever way they're going to.
Right, and you're saying there's only been two, one in May was his birthday, the birthday was in May.
Right.
And Christmas, that's it.
Right. It's very sad for my client, so.
Thank you.
Thank you. 868, in the matter of R.W. Burroughs Grantor Family Trust. Morning.
Good morning, Your Honor. Timothy Fergus of McCarter and English on behalf of Michael Limbarsky, trustee of the R.W. Burroughs Grantor Family Trust for the benefit of Ava Burroughs and Audrey Burroughs. May it please the court. We've brought this proceeding under SCPA 2103 and 2104 to recover the...
We're well aware of all that. Why don't you get right into it?
Yes, Your Honor. So the basis of the... there's a disputed transaction that the respondents, the executors of Bill Burroughs, claim is an equivalent transaction, and it was not, Your Honor.
Can you describe the nature of the stock that was exchanged?
Yes, Your Honor. It was closely held stock in a company that was known as Burroughs Waterworks that was removed from the trust and was replaced with another closely held company known as Burroughs Paper Corporation. And the basis of the position of Bill's executors that this transaction was an equivalent exchange was a divorce settlement agreement of which my client, Michael Limbarsky, was not a party. He was not a litigant in this divorce. He was not a party to this divorce settlement agreement. And if the court reviews the settlement agreement, of course, the court will see that there's no signature of my client on the settlement agreement, but it goes much further than that, the issues. In fact, if you look at the settlement agreement, the party to the agreement, who was Marcia Burrows, my client's sister, that Marcia Burrows, in fact, did not agree to any valuations of stock. If the court examines the entire settlement agreement, there is not one reference to an agreement or consensus as to the value of stock. In fact, there's no reference whatsoever to values of stock, period, within the entire agreement. So there was no agreement or consensus as to, certainly on my client's part, but also on the part of Marcia Burrows, who signed the settlement agreement, as to the value of the stock that was exchanged. Now, Bill's executors point to a stipulation of experts from the divorce settlement agreement, and they point to that document and they say there was a consensus of value in the divorce. That stipulation was unsigned. There is no signed stipulation, and certainly if there was a signed stipulation, it would have been produced in the prior proceeding. But in any event, there is no reference to this stipulation in this divorce settlement agreement. It appears nowhere. It's not incorporated in the divorce settlement agreement. So
somehow the distribution of those assets needed to be allocated in a divorce.
The assets certainly were equitably distributed within the context of the divorce. That's correct. There were a number of issues addressed in this divorce settlement agreement. There were child custody issues. There were child support issues. There were divisions of all sorts of assets. There was give and take all over the agreement, Your Honor.
Okay, but they didn't litigate the values of the stocks at that point in time, those closely held stocks. So I'm just imagining they had to have agreed on those values or equivalencies or whatever, okay?
It's not clear, Your Honor, what they agreed on because there is no reference to agreed valuations. And in fact, if we read the settlement agreement, Your Honor, there's a specific provision that specifically indicates that there was no valuation of the stock. There was no actual valuation done. And why that was done, it's why that was not done, it's not clear because the divorce, my client was not party to the divorce, but certainly there were a whole host of issues that were dealt with in the divorce, and my client would have placed great weight on certain consideration, I'm sorry, not my client, Marcia Burrows would have placed great weight on consideration that she received in the divorce. For example, there's a provision that provides that the grantor trust agreement will not be modified, and that the Abe and Audrey's interest within that trust will not be modified, changed in any way. Certainly Marcia Burrows would have placed great weight on that provision in entering this divorce settlement agreement. In addition, the issues go much further. The computations of value that were the basis of this transaction were as of 2011. This transaction, in fact, occurred 2 years later in the year 2013. In addition, the calculations and the settlement agreement itself are inadmissible in this court proceeding. And in fact, the computations that were relied upon are actually stamped that they're inadmissible for settlement purposes, not to be used in any other matter. The surrogate's court didn't reference CPLR 4547. That provision, of course, means that that settlement agreements aren't admissible in separate court proceedings. Nowhere in the opinion did that come up. In addition, there's several other issues with these computations of value. They were contradicted several times over by the very people who calculated them. There's several different versions of these calculations that showed up.
We understand all that. We have to look into all that.
Okay, Your Honor. The court also did not consider the expert valuations that were filed in the court proceeding. And of course, there were expert valuations presented by both sides in the underlying case. Expert valuations that were actually as of 2013, the date when the transaction was conducted. None of that was considered. And moreover, I'd like to point out that the court made a ruling that my client hid behind his own inaction. I think that was the language that was used in the decision.
Can I just ask you something, though? With those
Yes, Your Honor.
experts, those were unsigned, weren't they not?
I'm sorry.
The stipulations, the experts' stipulations, those were unsigned.
That is correct, Your Honor. They were unsigned, and there was never any signed version that's been produced in discovery. We're not aware of the existence of any signed stipulation.
Okay.
The court ruled that my client, Michael Lemvarsky, hid behind his inaction But if the court reviews the chain of events that we describe in our court papers, the petition that was signed, and everything that has occurred here, it is clear that that was not the case. The transaction was proposed to my client in November of 2011. In December of 2012, my client voiced his concerns and his objections to the transaction, but nonetheless, the transaction was effectuated without him, and he was advised that it had been effectuated in March. Just 6 months later, my client filed a court proceeding to challenge this transaction. The court, neither the respondents nor the court cited any limitations period that would be below 6 months. My client acted diligently, promptly, filed this proceeding, and he has consistently pursued this proceeding. That has never changed. He never ratified this transaction. There is no estoppel. He has been pursuing these claims for 10 years, Your Honor.
And that's what we have to look into, make sure that what you're saying is correct, okay?
Thank you, Your Honor. I appreciate that. And just one final point, Your Honor. There's this reference to a 2016 company merger that occurred 3 years after the stock transaction in 2016. That's a red herring, Your Honor. The merger in 2016 of a company, of one of the companies, doesn't determine that the transaction was equivalent in 2013. It has no determination in that regard, Your Honor.
Thank you.
Thank you.
Good morning, Your Honors. My name is Cecilia Cannon with Bousquet Holstein here on behalf of Ava and Audrey Burrows, the beneficiaries, who were minors at the time this motion was submitted and turned 18 and hired me before it was decided in the 4 years that it was pending. So if I may, having heard the questions that were asked and your familiarity with the case, I actually want to follow up on a few questions that were just asked, because I think Your Honors are getting straight to some of the heart of the matters. So specifically, Judge Greenwood, you asked what was the nature of the stock, with the answer being closely held entities, both the stocks that were switched. And Judge Bannister, you asked, isn't it the case that the distribution of proceeds had to be adequately addressed in the divorce? So as we had pointed out in our papers, these were extremely wealthy individuals. You're talking about hundreds of millions of dollars of assets that were being divided between them. There were 23 different business entities that had to be divided up. There was real property in the United States as well as abroad. There were luxury automobiles, precious metals in raw form, with jewelry. I mean, extremely wealthy people, right? This settlement and opting out agreement, the divorce agreement, was deciding how all of this was going to be split up, as well as custody and child support. So no, they didn't decide on specific values for BPC, Burroughs Paper Corporation, and BWW, Burroughs Waterworks, because it was just one tiny portion of the whole thing. And we cited in our brief the specific language in the signed divorce agreement where they explicitly said, hey, we didn't decide on values for all of this, but we've had enough information to be able to decide that this overall settlement agreement of these vast assets of these two people is in each of ours best interest, that being Bill and Marcia Burroughs, not Ava and Audrey, my clients, right? So no, they didn't have to decide it in the divorce. There was too much, I think, is the reason why, right? And they just came to a conclusion as to a dollar amount that Marcia Burroughs would get in addition to child support, and that was that, right? Save the cost of litigating all of these vast assets. So, Judge Smith, I believe it was your question where you asked, wasn't the stipulation of experts unsigned because my colleague had referenced the fact that there were expert reports submitted. There are two different things, all right? And if you look in page 55 to 56 of our opening brief where we have that chart, one of those is a reference to expert reports that each side had filed with the court, and so that they were part of the record of the case. Wasn't involved then. I can't tell you why. That was how the judge decided. Each of you get your expert report, file it with the court on its own. That's what they did. So the expert report that I believe my colleague was referencing was the expert reports which were provided in there. And those values, if you look at that, the expert report for Marcia acting at that time on behalf of my clients, Ava and Audrey, who were then minors, right, and the trustee Lingvarsky, that was $107 million was the value that had been put in with respect to, in that expert report for one of these entities, which was many times different from what the value was that was used in the swap. So two different things. The unsigned expert stipulation, which, I endorse what was said here. If there would have been a signed version, they should have put it in, right? They didn't. They can't. And the deposition testimony that they cited to, there's nothing that clearly links the document that they're saying was being talked about in the deposition to that deposition. There's just no proof that that was being talked about. I also think the deposition testimony is ambiguous as to whether it was ever signed. Even if it was, to turn to this assertion that Marcia Burroughs in the divorce agreement had signed as if she was a trustee of the BGT, right? So that was one of their arguments, that she bound the BGT because she signed the divorce agreement as trustee, not just individual. Well, it's as I think we put forth in our papers, very unsupported. But even if we had said that she did, right, which we don't concede, but for the sake of argument, if you look at those 5 provisions, I think what they're relying on is E, which is a release of Bill Burroughs for actions that he took as trustee. 2 things to note. First of all, the asset swap had not occurred at the time that that agreement is signed, right? So it's a subsequent action. So even if that release applied somehow, it doesn't apply to something that happens after the date it was signed.
We understand that.
And second, he wasn't acting as trustee when he allegedly went forward with the assets swap. So really, the divorce agreement is entirely irrelevant to this question. Now, the main focus of the brief is really on this ratification argument. I would just note for a moment here, in our opening brief, we had spent a lot of time on various estoppel arguments. And then, in my view, respondent's response is essentially a concession that none of those estoppel arguments support the court's underlying decision.
Okay.
So we won't talk about that. It would have been easier if the court had said what legal theory it was relying to find its holding, but they didn't. With the ratification and acquiescence, which, again, it's this can't rely on own inaction. I would note that the court in that part of the decision, immediately above that statement about the trustee Lingvarsky can't rely on his own inaction, it had noted a material issue of disputed fact. It said, respondent, or the estate, right, is who it was saying. The estate says that he acquiesced and ratified, and trustee Lingvarsky and Marcia on behalf of Ava and Audrey say he didn't acquiesce and ratify. Doesn't cite any of the evidence put forward on either side, doesn't talk about why, there's one, he should grant one over the other. He just says the trustee can't rely on his own inaction.
We understand that.
So it's essentially a determination of a disputed issue of material fact, which should not have been made on summary judgment and was inappropriate. With respect to the argument that was raised in papers that the promissory note, that the early payment of the promissory note was ratified by the trustee because they didn't continue to make payments on the promissory note. I want to give the court an example that I think really illustrates the ludicrousness of what they're asserting the trustee should have done. Imagine that you borrow $500,000 from the same bank where you maintain an account where your savings are, right? You're paying on that promissory note in compliance with it, all your payments are on time, you're not in default. There's a provision in the note that says the borrower can choose to prepay at any time if they want. The bank looks and says, wow, look, you've got $600,000 sitting in your account. I'm just going to take that $600,000 in full payment of my note. Thanks. It's crazy. That would never, no bank would ever be allowed to do that, right? So their suggestion that that he ratified these actions because he didn't then continue to make payments on the note when they had already grabbed the assets out of the trust, it defies common sense. And as to accepting the benefit of the Burroughs Paper Corporation shares being within the trust, again, we would say principles of mitigation of damages would say that he should do what he did, right? This is where he's left. It's a closely held corporation. This is not something traded on Morgan Stanley. They were back in Burroughs headquarters, right? They changed the ledgers, they changed the stock shares for their closely held shares without his knowledge. He doesn't find out for 3 months later because it's a closely held corp. It's not like you can just log into your account and see. And so their response is essentially what? He shouldn't have accepted the money when it was sold 2 years later. That was after this proceeding had already been initiated, and as we pointed out in our papers, before that 2016 sale went forward, again, 2 years after this action was already started, there was an agreement between the parties that the proceeds of the BPC shares, that those would be held within the trust and that no principal would be distributed from either trust. And in this respect, if you look in the site, there was a previous appeal in this estate and related trusts. We cited to the record on appeal for one of those two stipulations, because one of them is here in this record as it relates to this case. The stipulation that the Joy Burroughs Trust was restrained was part of that other record on appeal, and so therefore it's something that the court can take judicial notice of, has before it as part of the overall record.
Anything further?
No, Your Honor. We would respectfully request that the matter be remanded for trial.
Thank you.
Thank you.
Good morning, Your Honors. Robert Roche for the respondents, Jane Wayne Burroughs, Eva Dreyfus, those are the executors of the estate, and Carolyn Zaklukowicz. I'd like to address the issue about, number one, the expert stipulation and the argument that it wasn't signed. There is testimonial evidence in the record that it was signed. In fact, I deposed Mr. Ranucci. He was one of the two valuation experts on behalf of Marcia Burroughs, then in her capacity as co-trustee of the grantor trust. He clearly stated that that agreement, that stipulation was signed by not one but all three of the experts. And that point has been ignored. It was never brought up before, but it's now being raised. I think for purposes of trying to somehow show that this decision should be overturned, it should not. A big part of this decision has to do with the failure of Lingvarsky, the then trustee under the grantor trust. As the court stated below, his inactions he may not rely on. And his inactions were clear and evident that he ratified the transaction. He ratified it by going through 3 years after the fact with a merger transaction where the sale of the BPC stocks that was exchanged, Lingvarsky received $28 million. $28 million represents more than 200% greater value than the exchange transaction that occurred in 2013.
Counsel, how could he ratify it if he didn't know the actual value?
He ratified it, he knew the value. We had stipulated, we had advised Mr. Lingvarsky in a letter of December of 2013 that the values were what they were. They were identical to the matrimonial values. There was no issue about value until after the fact. In fact, this was a 2103 garden variety turnover proceeding to turn over the securities that were allegedly
Can I ask you a
unlawfully.
question about this ratification?
Yeah.
However? Did you assert that ever?
Did we allege?
Yeah.
We had made a motion, cross-move for leave to assert.
Wait a minute, but did you assert it in your answer?
We had made a motion for contemporaneously with opposing the motion for summary judgment for leave to amend our answer to assert a
For leave
ratification
to
claim.
amend your answer, but
Yes.
you never reached that, correct?
The pleading was never reached.
Okay, that's
and the
what,
court-
just want to make sure I had that right.
Okay.
Thank you.
Ratification was not only in respect to the going forward and the accepting value, $28 million from the merger transaction, but in treating those assets from day one, in 2013, when there was exchange, as assets of the trust. In fact, Lingvarsky admitted during my deposition of him that the only asset of the trust was this exchange stock. There were no other assets, there was no other liability, and the liability that we're talking about, this promissory note, was $4.7 million. But for the exchange transaction, that would have been due and payable on December 9th, 2018, which would have been a default. A default would have removed from the grantor trust the other stock in BWW, because that was served as collateral. for the note.
We'll look at that.
Okay. And
Anything further?
I would just want to add about the issue about the beneficial, or the benefit that was claimed not received by Lingvarsky in connection with this case. Ms. Cannon had indicated in her brief that she cited the case of Lamarca, Fourth Department decision, where there the individual was found to, on summary judgment, ratified a transaction, taking no action for three and a half years. Ms. Cannon indicated that it was 6 months before Lingvarsky woke up and decided to contest. But the contest here was, number one, it wasn't 6 months, it was actually 9, because this was started in September of 2014. But even so, it's been now 10 years, approximately 10 years since the anniversary of this exchange transaction, and Lingvarsky and the grantor trust continue to take the position that those shares of stock are the only asset of the grantor trust, that liability of $4.7 million was paid off in connection with the transaction. So the idea that there was no benefit is belied by the record in this case.
Thank you.
Thank you.
869 Meisner versus Ridge Construction, Inc.
Good morning, may it please the court. Oh, I'm sorry.
Can I ask?
Oh, I'm sorry. This is Mr. Harlow. He was on the brief. He won't be arguing with.
Okay, thank you.
Thank you. Good morning. May it please the court. Megan Brown, on behalf of the defendants, appellants, certain underwriters at Lloyd's London. I realize we've presented this court with multiple reasons why the judgment in favor of plaintiff should be vacated and the complaint dismissed. And despite the volume of the materials, the issues on this contract case are issues of law and not issues of fact. And I'd like to make my way through several of these issues, but mindful of my time, I'd like to first address the most uncomplicated basis for vacating the judgment, and that is that the plaintiff's notice to underwriters was late as a matter of law. It's undisputed that plaintiffs provided the notice on May 29th, 2019, and it's undisputed that they had actual knowledge of the insurer's identities on March 22nd, 2019. They also knew by then that the underlying primary insurance had been issued by an insolvent carrier, and they believed the excess policies were immediately available to respond to their claims. The delay of 68 days from when they had that information until they provided notice was late as a matter of law.
Okay, so during that 68 days, did everybody just fall asleep, or were there things happening during that time?
Well, there was the underlying litigation was going on, but as far as notice to underwriters, there was no notice until the May 29th notice.
Okay, so that's a notice that you accepted as a good notice. Wasn't there some earlier notifications that were rejected by you?
That was the first notice to underwriters, was the May 2019 notice.
Okay, and they were unaware of the ongoing litigation?
I don't believe they were made aware of it. That was the notice that was disclaimed by the letter from Mr. Gardner in June. So that's the notice, and that's there's some discussion about an email notice that happened later in July. So the notice was already late by that time.
In your view?
I'm sorry?
In your view.
Fair enough, Judge, thank you.
Counsel, your
Yes.
position is that that's a matter of law.
Correct.
Now, what if the judge saw it the other way? As a matter of law, it was reasonable.
There's no cases that say a 68-day delay.
But you presented that as a question of law, not fact, right?
Correct. Yes.
And that's what he did decide, though, right? That it was reasonable as a matter of law based, because there's no dispute factually about the sequence of events or what happened when.
Correct. That's correct. There's no dispute factually. He kind of says notice was timely and then engages in an analysis of the excuses that were offered by the plaintiffs, which we submit was an inappropriate factual inquiry. The issue should have been notice is late as a matter of law, okay, dismissed, or notice was late, are there excuses that need to be evaluated? We submit the excuses were unreasonable as a matter
Well,
of law.
in this case, plaintiff's counsel sent the notice out 4 days after the Bridges counsel said we may not have notified our excess carrier. It was 4 days.
Correct.
And that's not in dispute.
Correct. But they had already had the physical policies since March of that time. So that's what we're saying is the condition precedent for coverage under the contract of insurance required notice as soon as practicable, which is measured from the date they had the policies in hand, and not, I think relying on someone else to make notice is perhaps at their peril at that point.
So if someone was to say, oh, we can't decide as a matter of law that you're right, what's the remedy? A trial on that issue?
I think if you're saying, then you have to reach the reasonableness for the excuse, right? So then the question becomes, was it reasonable to rely on this meeting with counsel?
And your point is that can't be resolved on a summary judgment motion.
Correct.
It's either a matter of law in our favor or the finder of fact has to decide the reasonableness.
Correct. And that wasn't addressed here despite the procedural irregularities, because it was always going to be, the notice issue was always to be decided on the summary judgment record. So any factual analysis here we submit was an error by the lower court.
Okay.
Additionally, and I won't belabor the...
I'm sorry.
That's okay.
Just takes me a while to formulate my question here. All right, so there was 4 days between the time that plaintiff was made aware that there might be a notice problem, okay? We might not have let our excess carrier know of this problem, okay? And 4 days later, they were officially notified? I'm just trying to figure out how that could possibly be late as a matter of law.
Because at that point, it's not about when Ridge provided or didn't provide notice. It's the right of the injured party to provide notice. And notice is a condition precedent under the contract, separate and apart from the statutory claim. And that's...
Did the claimant or the plaintiff have any reason to believe that that in the course of your business, your insurance business, that that notification would have been made? Could they rely on that in any way?
I don't see any cases that say they can, and I specifically point the court to the Mu Yan Lin case that we cite in the 3420 context for late notice. The contract is the contract, and notice has to be provided. And sitting on that, once they had the policies in March, that's when the clock starts to run.
Okay, we'll look at that.
All right, thank you. And beyond that, and I won't belabor our arguments with respect to the excuses, I think we covered that, Justice Del Conte. Also, the disclaimer from underwriters was proper, and it doesn't excuse any late notice. It went to the real party in interest here, which is the plaintiffs through their counsel, and that's the Cincinnati and the Excelsior cases. Moving on from notice, that's not our only argument here, so moving on.
So get to your other ones, because you're running out of time.
I appreciate that, Judge, thank you. There was no proof of underlying and proper full exhaustion here. So even if you can get past notice, which we think you can't, you don't get to the underwriter's policies. There's no dispute those are umbrella and excess policies, unless there is exhaustion of the underlying policy. And here there's no proof that there was exhaustion. Frankly, plaintiffs are put on the record on May 6th that the limits of the lumberman's policy had not been paid, so there was no actual payment here, and that's at page 10436 of the record, and it's quoted in both of our briefs. And frankly, I would submit that the plaintiffs abandoned the argument that there was actual payment when they adopted this sort of novel credit approach, because if there had been exhaustion, you wouldn't need to apply a credit.
Yeah, but there can't be exhaustion here because lumberman's is never going to pay.
Well,
right, that's why the credit.
Well, the credit, there's plenty of cases that say insolvency is not exhaustion. So you can't just say, oh, they're insolvent, forget about the primary policy, now we go to the excess carrier. That's not how this works. So you have to look at exhaustion in the context of all of the case law that exists, and Rapid American is a good example.
But here the
case.
verdict exceeded the primary policy by millions of dollars.
It did.
They were already into the excess.
It did.
And the primary carrier was defunct, couldn't make the payment.
Correct.
So they said, listen, we'll just credit you $1 million and then let's get to the excess. And you say that approach was novel and
Correct.
contrary to law?
That's correct. And I believe it was contrary to this court's decision in the Carrier case from 2020. And in any event, what I'll note is the plaintiff's own expert did not apply this credit. They testified that they applied an all sums allocation and they allocated to the lumberman's primary policy. So they didn't even apply the credit that now we're talking about. They applied this all sums and allocated to the lumberman's policy. And so that leads right into the next point here, which is that the all sums allocation methodology that was applied was incorrect because it's undisputed that the lumberman's primary policy did not contain prior insurance non-accumulation clauses. And the case law out of the Court of Appeals is very clear that in a policy without that language, you have to apply the pro rata allocation. And plaintiff's own expert testified, if a pro rata method of allocation was applied, you don't even get to the underwriter's policies.
Do you have any other arguments?
Judge, just briefly, I'll submit that, and just reiterate that the court below applied the wrong trigger standard. It's been refuted that exposure alone, it's certainly not a correct injury in fact rule for trigger. And I would cite again to this court's Carrier decision and also point to the Keysby decision. And then just finally, I would, on the substantive issues, the plaintiffs did not meet their burden to demonstrate that Mr. Miser's injuries were neither expected nor intended. And I know we talked that at the end of the brief, but it's just as important. And I would point to the Johnstown case. And finally, just reiterate that the procedural irregularities here certainly compounded these legal errors. And I think for any or all of these reasons, the judgment should be vacated and the order reversed. Thank you.
May it please the court, John Lipsitz for the respondent. I would beg your indulgence because, of course, there were a number of issues that were brought up rather rapidly. Let me start where Ms. Brown started. And she discussed notice issue, and I would submit that the standard of notice for an injured party under the First Department's decision in Loretano, 1957, which was affirmed by the Court of Appeals, sets up quite a different standard than the standard that applies to an insured. And it's instructive. Three things that Loretano said, and the court said in that decision, are highly instructive. First, that the statute, having granted the injured person an independent right to give notice and to recover thereafter, he is not to be charged vicariously with the insured's delay. That's the first thing. Next, the purpose of the passage of time does not itself make delay unreasonable. Promptness is relative and measured by circumstance. That's the court's words. Then, I'm paraphrasing here very briefly, hindsight might suggest a different course of action for plaintiff's counsel. Now I'm quoting. But plaintiff's efforts must be judged by the standard of what appeared reasonable at the time. That is to say,
Counsel,
reasonable to them at the time.
Right, and counsel, the question is, I think that the argument here is whether it's reasonable or not can't be decided on the summary judgment motion.
I beg to differ. I think it can be because there's no dispute about the basic facts, and it's objectively reasonable under these circumstances where we had litigation that began on the underlying case in November 2018. There were pleadings were exchanged. There was a deposition of the plaintiff. At all times, Ridge was represented by a law firm with experienced counsel that had a history of representing both Ridge and Kodak. There was no reason for us to spend our time, instead of preparing for the underlying case, to go on an archaeological search for coverage in a case going back to the early 1970s. We had a reasonable expectation, and I think this is objectively the case, to assume that Megan D. Pasquale of the Ward Greenberg firm, who was representing Ridge Construction, which admittedly was a dissolved corporation, but somebody was paying her bills. And there's a sort of presumption, or I think it's a fair thing to say, somebody shows up representing a corporation which had a tie to a massive corporation, that person's being paid. They don't do it on a volunteer basis. And it would in effect be probably some sort of malpractice, not for them, the insured, not to have, put on the insurer on notice. So we were in a situation where what we were doing was objectively reasonable. And when we learned on May 24 at a conference that was actually initiated at Megan DePasquale's request, we were there at the conference and we were told, well, there's a problem here. We might not have put the excess carriers on notice.
And then you did so in 4 days.
4 days. And not only did we do so in 4 days, we gave them notice that was detailed, that explained.
We understand all that.
Okay, great. Then, let me get back to,
Would you say that was your first understanding that there really may have been a missed opportunity here? The first time that you understood that, oh shit, we didn't, there's no notice.
Absolutely. We had not an inkling prior to that.
Right, okay.
So
I guess the question would be, should you have had an inkling? Okay, their presentation was that all of the evidence was there for you to have that inkling, and you knew who to contact, and you didn't contact them until, you were explicitly told that there could be a problem.
hindsight is 20/20. I mean, we were delighted that there was coverage, and we reasonably assumed and believed that the carriers had been placed on notice. We had no contractual relationship to the insurance contract. The statute, actually, the statute as written, and the history of the statute says we had an independent right to provide notice. I mean, we didn't do the legal research to find out, parse the difference between an independent right and an obligation. We did what was reasonable. But the statute doesn't, by its own terms, impose some kind of obligation on us at that juncture of the litigation. And the only case they really can cite is Muyan Lin. And in that case, there was a default judgment. It took years to contact the carrier. The insured had been obdurate, recalcitrant. The injured party knew who the insurers were and didn't do anything, didn't contact them, went through the whole business of getting a default judgment and then tried to enforce it. It's totally inapplicable. And the case is easily distinguished on its facts. Then,
let me interrupt you one
Sure.
more time, okay? So there's a provision of the law that says that you can notify an excess carrier.
Yes.
Okay. But it doesn't require you to do so? Is that what you're saying?
Our argument is that under these circumstances, at that juncture, there was no affirmative obligation on the injured party to provide notice.
And
It was, I'm sorry, Your Honor, it was 5 or 6 months before the trial, 6 or 7 months before verdict and judgment, and we had in fact provided detailed notice to the carrier.
Okay, and there was some actual notice to the carrier?
I was going to get to
Okay,
that.
I'll let you get that.
And I really appreciate that. And it all plays together with this question of disclaimer. Because a disclaimer is sent by a Mr. Gardner, who works for Resolute, which is the agent for the underwriters. And the disclaimer, and I think I need to give you this preface first, and then I'll get right to that, what you asked. The disclaimer it itself was untimely. It came 28 days after Mr. Comerford's letter of May 29th. It was not issued to the insureds, that is to Ridge or Kodak, in blatant violation of a clear statutory command in 2430 or 3420. It did not disclaim on grounds of late notice by the insured, by the way. All it said was the injured party was late. In fact, it used the word lipsitz, kept saying my name, you're late. It had nothing, didn't say in any way at all that Kodak or Ridge were late. And by the way, and they say, well, you know, it doesn't matter because Mr. Comerford shared this with, Ms. Di Pasquale, and so it doesn't matter. Well, even had he, first of all, there's no case law that would support that as an excuse, but even if he had, she would have seen that there was no disclaimer as to her client's involvement. It didn't raise the complete, anything about, well, there's a couple of things it didn't raise. It didn't raise the injury in fact business, the Keysby business, and it didn't raise anything about pro rata as opposed to all sums allocation. But now getting to what you had asked me. On July 9, and the days running up to it, Kodak, and there's a testimony from, excuse me, I think I want, just so I have the right name. There's testimony from one of their people who was in charge of, yes, it's a Matthew Ebersold. Matthew Ebersold was at Kodak, and he had a team of people going through boxes and lists of...
Why don't you shorten it up, because
Okay.
you're running out of time.
So he puts together this tender, and it goes out to all these people, including Resolute. And according to the testimony of one of Resolute's people, Mr. Barabal, that would have gotten into the hand, that was forwarded to Mr. Gardner. So Mr. Gardner actually had notice from Kodak on behalf of Ridge and Kodak. Mr. Gardner's at Resolute. He represents the underwriters. He's got notice, doesn't disclaim. And then he has the temerity a couple of days later to send a letter on August 7th to Mr. Comerford saying, we never got notice from Kodak or from Ridge. They had. I mean, I'm not accusing him of lying, but you can't run an organization that provides an agency for an insurance company and say, well, one hand didn't know what the other hand was doing. They had notice. They never disclaimed as to Kodak or Ridge. They had notice from us and never disclaimed as to Kodak or Ridge, and that's mandatory.
And I know your time is up, but I have one more question, okay? Sorry, Judge Smith. All right. In this record, I'm reading summary judgment papers, and then I'm also reading testimony, okay? And I'm confused about that. I mean, did we have a hearing on the merits of this claim already and a decision by the court or not?
We had a number of issues, but the issues that were the subject of the testimony in, I think it was February, April, March of 2021, were from medical experts primarily and from some allocation experts. And the medical experts weighed in on the question of whether there was injury during the policy period to Mr. Meisner that was the cause of his mesothelioma. And the judge heard two witnesses that we proposed and two witnesses that were proposed by underwriters. Listened to all the testimony, and he concluded that there was factual evidence supporting the occurrence of injury to Mr. Meisner's lungs during the policy period 1970-71. And I think if I've run out of time, what I would have talked to you about was Viking pumps, and their understanding of Viking pumps is totally upside down and backwards.
But you'd like us to take a look at that?
I would absolutely, because Viking pumps says, you know, the premiums were paid for the excess policy. The excess policy had the non-accumulation of limits clause in it. It doesn't matter that the unavailable liquidated primary layer didn't have the non-accumulation of limits clause in it, because the non-accumulation of limits clause says, with respect to the responsibility of the excess carriers, you are on the hook for all sums. You don't want some kind of stacking? Fine. You're going to get all sums, and they have vertical exhaustion and can go up the tower, up the coverage tower. And that way we can satisfy the judgment. Okay. Thank you, Your Honor.
Thank you very much.
All right, the next case, matter of Save Monroe Avenue, Inc. versus the Town of Brighton. And Judge Smith is recused. Okay, counsel, we've seen you here before,
Been here a few times,
a
Your
few
Honor.
times. Why don't
Charles
you-
Malcolm from Hodgson Russ for the Save Monroe Avenue appellants. Your Honors, the way incentive zoning is supposed to work, as articulated by the Court of Appeals, is that it's supposed to be used to get something that the community could not otherwise require of the applicant in exchange for deviations from the zoning law. And the town code of the town of Brighton has codified that in its laws. Specifically, turning to Town Code Section 209-3B, it provides that the amenity shall be in addition to any mandated requirements pursuant to other provisions of the comprehensive development regulations. That's the zoning law.
And that
okay?
includes anything that would be a seeker modification.
Exactly. And the reason for that, Your Honor, is because seeker doesn't confer any additional jurisdiction on the agencies. Seeker requires the agencies that exercise their existing jurisdiction to utilize it to mitigate impacts to the maximum extent practicable. Here, it was the town's zoning power through the comprehensive development regulations. So all of the seeker mitigation measures were done through the zoning and through the comprehensive development regulations.
So the town was in charge,
Correct.
and the town had to decide whether or not these extra things that were being done would have been required under seeker, or whether they were pure benefits that couldn't have been conferred in any other way than this incentive zoning.
Correct, Your Honor.
Okay, and, you know, I'm not complaining about reading a lot, but I read two boxes like this of records, which talked about meetings and proceedings in front of the town where they appeared to scrutinize every benefit, every little thing that the developer was doing, and trying to, you know, make that distinction. And it almost appeared to me that they did that, excuse it, ad nauseum. Okay, like they at times they weren't sure that it was enough, and they called the developer back in and said, "We want more." That's my reading of that enormous record.
Your Honor, I would submit that a big box of documents doesn't cure defects in the law. And this is clear on its face that on the law they're wrong. And I'll go through piece by piece as to how that's the case. Let's start with what essentially they said there's 4 amenities, okay? And I'll cite chapter and verse in the record on how they're wrong. Number 1, they said that the project isn't going to go through the IDA is a benefit, okay? Well, let's take that one first. This project, okay, it's a retail project, categorically ineligible for IDA benefits. They can't have them. So what the town board said is, the fact that this project is not going to get IDA benefits, which they're not legally entitled to, is an amenity. Well, if you look at what the permissible amenities are in the town code, 209-3A, not getting comita benefits is not on that list, number 1. So it's not even eligible under the town code. That's setting aside the fact that under General Municipal Law 862, it's not eligible anyway, okay? So that's a potential, if you credit that, that's potentially millions of dollars in additional revenue that the town may think it's getting, which it's not eligible
You're
for
saying
in the
that's
first place.
illusory.
That's illusory, completely illusory. It's illegal, it can't happen. It's a
What about
lie.
the benefits to the pedestrian trail?
Well, first of all, you got to look at what's going on here. They're building a massive retail plaza on top of an existing heavily used recreational trail. Moving it and making it safer for pedestrians and rerouting the pedestrian traffic is a seeker mitigation measure. That would be an appropriate development condition that would be required under zoning.
My recollection is that the town board addressed that numerous times, that particular amenity, to see, and make a determination whether or not that was, over and above the seeker modifications that would have been required.
The court below noted that they made a modification to that. First, it was only on-site. Then they went and did some more stuff off-site to make that one amenity a little bit bigger and to try and say, look, we're going to do some off-site improvements. I would submit that as part of this large of a project that's going to have this significant impact to pedestrian access because you're relocating a trail and the fact that you're going to have this much traffic in that area, that the town could have required that under seeker. But if you credit that and you say that a piece of that could be considered an actual true amenity, That doesn't make up for the fact that every other aspect of the amenities that were credited were seeker mitigation measures and development conditions, and that it totally skewed the analysis that was done by the town board, and the whole thing was affected by an error of law. So even if you want to say, we're going to give a piece of the trail improvements amenity credit, it doesn't cure the legal defect. But if you look at the other stuff, the access management plan, why do we need an access management plan? The number one impact of this project, and you mentioned, Justice Bannister, that I was here
We've seen you before.
the traffic, okay? The DOT noted that this was mitigation. Town Board Volume 4 at 010526 noted that the access management plan was necessary seeker mitigation. The DOT was an involved agency under seeker and had an obligation to suggest necessary mitigation. This was noted in the findings. And I would note, the town board certified that without this mitigation, they couldn't have approved the project. So it was required mitigation. They certified that the impacts were mitigated to the maximum extent practicable. It was legally required for them to do this, to approve the project. Town board members admitted that these were mitigation measures. We referenced them in our brief. Town Board, Volume 5 of the record, 012787.
But can't something be a mitigation issue, whatever, and then be an amenity also, because they go far beyond what's necessary for a mitigation?
No, because the town code says the amenities shall be in addition to any mandated requirements to other provisions of the comprehensive development regulations, and all of these amenities were certified by the town board that they were necessary for seeker compliance. And because they were certified as necessary, they were required. That goes back to the Trinity Place case, Your Honor, and that is that you're supposed to be able to get something over and above what you could otherwise require. All these things could be required. And I would also note the preservation of open space. Town Board member Luis Novros said, "The preservation of open space as a buffer to adjacent neighbors are always expected by the town as mitigation for new developments." Every single one of these amenities, mitigation.
Okay. So I think your argument is that despite these boxes of papers outlining many meetings between the developers and the town, that they got it wrong, and we need to do something about it.
It should be remanded to the town board for a new determination to consider only those things that are proper amenities. That's the remedy here.
Okay.
And I would note that Town Code Section 2095F requires the town board to make a sufficiency determination. They're required to take a look at what are the incentives. And if you look at the incentive zoning resolution, Schedule F, there's a list of a couple dozen incentives that they're requesting. Pretty significant. The town board never calculated what the value of those incentives were to the developer. We did, $17 million. Now they ignored that and said, we don't have to look at that. But how do you evaluate the sufficiency of the amenities when you don't even have a number that you attach to the value of the incentives to the developer? That was never done.
So it's your position they did it improperly?
Correct. Even if you only look at the fact that they credited no IDA benefits, how is that decision not affected by an error of law? The community has been shortchanged on amenities because the town board made a decision thinking that things were amenities that weren't, and that sufficiency analysis was tainted by an error of law.
Okay, thank you.
Thank you, Your Honor.
May it please the court, John Mancuso for the town of Brighton respondents. Judge Bannister, I believe you were correct in pointing out that the town board heavily scrutinized this project as reflected in the record over a period of 3 years as to precisely evaluating the value of the amenities and the benefit that these amenities would provide to the public.
So counsel says, okay, you did a lot of stuff, okay, but you didn't do the right stuff and you didn't do it properly. What do you say to that?
A couple of points. I believe that SMA is really asking this court to create new law. They want limitations inserted in town code that do not exist. They want a categorical legal prohibition on a town accepting an amenity and making that illegal where it may also mitigate a seeker impact. That is not supported by Town Law 261B. That's not contained anywhere in the Town of Brighton's code. It's not contained in any New York case. It's not unlawful to accept an amenity that may also mitigate an impact to what Justice Greenwood identified. They may serve a dual purpose. The standard under the statute and under the town code is whether the amenity provides a sufficient public benefit to provide the requested incentive. That is the standard by which the town board judged this, and as the record reflects that they judge this. It's a factual evaluation. It's not a legal prohibition. The weight to be afforded to the amenity is judged by the facts and by the record before the board for the particular project and the particular amenity. And that factual evaluation is well developed in the record. We cite it chapter and verse in our brief, but the board in the FEIS identified the standard. It has to exercise its sound discretion in determining the value and the proper weight to be given to the amenity. So they spent 3 years looking at the sufficiency of these amenities. When we started this project, the amenities that were offered by the developer with respect to the trail amenity, for example, it was 1,000 feet. It ran through the project site and only through the project site. Through years of evaluation and comments by the town, comments by the public, as reflected in the record, that amenity was expanded significantly. I think SMA gives very short shrift to the fact that this now spans the entire town of Brighton. It goes from the city of Rochester all the way to the town of Pittsburgh, well beyond a mitigation of the project.
Okay, did you put a value on that? I mean, is there a value on the excess work that you've done that was greater than what the mitigation cost would be?
Well, I think the issue is what is the standard for determining that value? SMA would propose that that value is simply tied to a monetary value. What was the physical cost of the construction of the trail? We would submit that that is nowhere to be found in the town code or the OCHA 61B. The standard of value is whether it provides community benefit. There's intrinsic non-monetary value associated with creating 2 miles of a pedestrian trail for the benefit of the public, beyond what the actual monetary value would be. And that's what Justice Odorizzi correctly found, and I don't believe that's inconsistent with the Asian Americans for Equality versus Koch decision. It predated the incentive zoning statute altogether. And I think if you can reconcile the statute with that case, it's simply reflecting that the statute is the mechanism by which the town has to weigh the benefit and the value. And that can be both monetary in terms of the actual cost. It can also be non-monetary in terms of the benefit it provides. And to get back to this issue about the mitigation measure, I disagree completely with the idea that simply because it may mitigate an impact that disqualifies it entirely as an amenity. A stormwater management, if I could just have a brief example of this, if you had a stormwater management facility that was solely mitigating impacts associated with a particular project, that goes to the weight of that amenity. It's not categorically prohibited. It may not provide sufficient value because of the narrow scope of that amenity, but let's change the facts. What if this area in question has significant drainage issues? If residential properties surrounding the project were also suffering from drainage, from stormwater flooding and other issues? If a developer came in to develop an amenity that not only handled on-site stormwater, but managed an entire area of stormwater management, what I would tell you is the town board could appropriately weigh the benefit of that to the surrounding area, not just its mitigation of the project itself. The access management plan is very similar to that example. When it started, it was essentially a traffic signal and some on-site related improvements to help mitigate the traffic from the project. After 3 years of studying that and multiple traffic impact studies, comments from the town and other evaluations, this was expanded. 8 properties across the street from the project. The entire corridor between I-590 and Clover Street were studied, and this access management plan was expanded. It's not simply mitigating the project. It's providing traffic improvements and safety improvements along the entire corridor, well beyond what seeker would require the town to impose. So I think the issue here is that SMA is asking for an expansion of the law. a new rule that categorically prohibits it. We are simply applying very well-settled principles of statutory construction coupled with the town board's deference that it should be afforded to evaluate these impacts. And one final point that I would like to make is Section 209-3B, the section that's being relied upon by SMA that states that an amenity shall be in addition to any mandated requirements. There is nothing in the town code that mandates that the town impose seeker mitigation. It requires that we comply with seeker. Seeker does not require an agency to impose every conceivable mitigation or any particular one. That is a well-established principle from Jackson and the Court of Appeals and has been cited numerous times over the decades. The other provisions of our code, there is nothing that would mandate these amenities. And with that, unless the court has any questions, I would otherwise rest on our papers.
Thank you, Counsel.
Good morning. May it please the court. John Nutter for the developer respondents. The developers join in the town's arguments and their brief. We did not submit a separate brief because we join fully in the town's arguments and request that the trial court's dismissal of these incentive zoning related claims be affirmed. We believe that the trial court appropriately found that the adoption of this approval was supported by a rational basis in the record. The trial court appropriately recognized the deference provided to local officials in making judgments with respect to local zoning and land use. With that, we rely on our papers unless you have any questions.
Thank you, Counsel.
Thank you.
$873, Ezra B. versus State of New York. Oh, I'm sorry, and Justice Del Conte is recused on this matter. Just a minute. Great. Okay, go ahead.
Good morning, Your Honors. Andrew Pluinski on behalf of Mental Hygiene Legal Service and Appellant Ezra B. May it please the court. Supreme Court's finding in this matter that the appellant was a dangerous sex offender requiring confinement was against the weight of the credible evidence adduced at the hearing in three precise ways. The first is that the appellant's predisposition to sexually offend as being currently strong is not supported by the weight of the evidence, nor is the finding that appellant is unable to govern his sexual misconduct. And third and finally, that if released to assist, appellant would be likely to commit a new sexual offense. Now, turning first to the first point, I note for the court that appellant's qualifying offense is indeed his only felony sex offense, which was committed in 2014. Now, since that time, there's been no sexual offending, and that includes a period of at least 4 years.
He, however, has admitted that he has victimized at least 18 children from ages 18 to 17, correct?
That's correct, Judge. And in light of your question there as well as to my client's admissions, he's acknowledged the past transgressions in treatment and has been working with this treatment. And a fact that both experts in this case recognize that he's making moderate progress towards his treatment goals. And I believe it was Dr. Hackworth who testified on the state's behalf, conceded that appellant had insight into the precipice of his sexual offending cycle. Now, I note as well that since that initial offense, which I believe was the last, as the record indicates, there's been no sexual offending when he had access to, as the state's expert opined, his preferred victim pool, that being children. Now, I do note, and I acknowledge for the court, that one of the probation or parole violations.
Because he wasn't supposed to be around children.
That's correct, Judge.
He said he was babysitting for children, living with children, being around children all the time.
That's correct, Judge. And I note that these were his own children, where there's been no allegation that he offended against any of them.
But only 2 of them were his own children. One of them wasn't his own, right?
I believe that's correct, Judge. And I, again, would just underscore for the court that there has been no allegation of additional misconduct, which he certainly would have had an ability to do, given that he was nearing and in contact with children. I do know
both experts agreed he could not be released safely on cysts, correct?
That is correct. That was the finding of both Dr. Bard and the state's expert, Dr. Hackworth. And so while both of those experts do certainly go against my client, Supreme Court, and by virtue of this court's discretion, has the ability to draw any opposing inferences based on the same evidence and render a fashion a remedy that may be.
We know that, and we'll look at that very closely.
Thank you, Your Honor. I would just note that my last point here, the actuarial scores underscore that somewhat of a discrepancy in the state's evidence here. Dr. Bard, who was the independent expert, found that there was only a moderate risk to reoffend, while Dr. Hackworth determined that there was a well above average risk. Now, the actuarial scores, the VRS-SO, the violence risk scale for sex offenders, and the static 99R, with respect to the static 99R, determined that there was only a 3.2% risk of reoffense over 5 years, and that's pretty low for some of the scores that we see typically. And then on the VRS-SO, those risk factors that even Dr. Hackworth conceded, appellant had made some dramatic improvements in, resulting in the reduction of the score by 3.5 points. And so with that, I request that the court reverse the determination of Supreme Court and order a regimen of assist for Mr. Bell. Thank you.
Thank you. Mr. Luxman? Oh, great, thank you. Go ahead.
Good morning. May it please the court. Brian Lusignan with the Office of the Attorney General representing the state of New York. Supreme Court's conclusion that Ezra B. remains a dangerous sex offender in need of confinement is supported by clear and convincing evidence, including the unanimous expert opinion, which set forth 4 distinct reasons that Ezra B. remains a dangerous sex offender. The first is that Ezra B. lacks insight into his sex offense cycle and history. He has denied being attracted to prepubescent children, despite also admitting to abusing almost 20 children as young as 3 years old. He has minimized the instant offense and blamed everyone but himself for it, and he has failed to address at all his lifelong history of sexual deviancy. Until he acknowledges and understands his sex offense cycle, he cannot make realistic plans for stopping that cycle if he's released to CIS. Second, Ezra B. has consistently failed to follow the conditions of probation. During his most recent period of probation, he engaged in high-risk activities by repeatedly having contact with children and using drugs and alcohol.
We understand
Counselor,
that.
can I ask you a question? So this order was issued August 16th, 2022. Is that right?
I believe that's correct, Your Honor.
Okay, so these are orders for a year?
Their annual reviews, my understanding of the current status is that they are waiting for expert reports to come in, so that review is ongoing. So this order remains in effect until that cycle is complete. So at this point, the case remains live. I will certainly notify the court if there's any change in that, but we're not expecting the reports until I think December or something like that. So there's some time here.
Okay, thank you.
And in addition to failing to follow the conditions of probation, which suggests that he's not going to follow the conditions of CIS, which are even more strict and rigorous, he lacks adequate family or community support. He's historically used his family as his victim pool. He's been inconsistent about whether his family is a positive or a negative support. And he has likewise used his church as an opportunity to have contact with children. Without realistic plans for community support, he's a poor candidate for CIS. Fourth and finally, Ezra B. scored unacceptably high on risk assessment instruments. The state's expert, Dr. Hackworth, is the only expert who considered dynamic factors in the risk assessment. She placed Ezra B. at the highest risk category with a 5-year recidivism rate of 29 to 48.5%. The independent evaluator, Dr. Bard, although assessing him as a moderate risk of reoffense, still viewed that risk as too high for release to CIS.
Okay, thank you.
Court of Appeals and Appellate divisions have held that all 4 of these factors are relevant to a court's determination as to the dangerousness of a sex offender. You can see those cases at pages 22 and 23 of our brief. Contrary to Ezra B.'s argument, the state does not need to establish that an offender has actually committed additional sex offenses.
I think we know all that. Thank you.
Yep. Okay. The evidence before the Supreme Court amply supports this finding, and its order should be affirmed. Unless Your Honors have further questions, we'll rest on our brief.
Thank you.
Thank you.
875 Essig versus Essig.
May it please the court. This was an unconditional payment of $15,837. There was no requirement that asked the plaintiff to give up any legal right. The case law says that any restrictions must be explicitly stated. The only thing that was here was attached as the payment as calculated by the State of New York Supreme Court of Appeals. Now, I think that may have elevated the trial court a little higher than it meant to. But the trial judge has provided impermissible inferences here. The inferences are, well, this is all that's due, I'm never paying again. That's not here. It has to be. It absolutely has to be for the court to have found the way it did. There has to be full and final payment. There has to be, something like that. We see this all the time. This is essentially law school stuff. And given the history of this, I don't know what else I could have done to give everybody the impression this was not meant to be full and final satisfaction. I made a motion to have the original judgment modified to reflect a $15,837 payment. Denied because the judge said they don't have to accept anything but the full. That's what partial satisfactions of judgment are all about. So then I went to the next step. Let's do a partial.
We know I understand.
Okay, I understand. It's just, I don't know what else could be more clear here. There has to be something that would indicate that this was $15,837 and nothing else, and that's it. In this particular case, they're saying that, I don't know, a principal who actually had the check still had it at the pendency of this appeal.
But they didn't cash it, so they didn't receive the money. They didn't cash the check.
Well, that's just it. I can't make them go to the bank. This was a legal tender. We ought to get credit for that. In fact, when the judge actually came up with this, hey, issue it again, and we'll give you this credit for a date that he completely picked out of thin air, they still had the check. It was still a live check. We cannot be penalized for the fact that they don't want to cash the check.
Well, wasn't it because they didn't cash it because it was the wrong amount?
It was a wrong amount for what? It would have been if we were asking for full and final payment. We weren't. It was just, here's the check. And again, I had already asked the court not to get rid of the entire judgment, but to only account for the fact that they had a check for $15,837. I can't be more clear that I'm not asking for full and final payment. And then to ask for partial satisfaction. They still had the check at that point. They could have cashed it at any time.
Okay, I think we understand.
All right, thank you.
Thank you.
Good morning. James DeStefano, attorney for the estate and for the respondent here. If you look at page 37 of the brief, of the record on appeal, I made it very clear that when the judgment was entered the same day on October 15th, send all the checks to me. And the judge applied that application and denied their motion to get credit for the checks that they never cashed. And we requested that be affirmed. I think the records are clear.
Is there some reason you didn't want to accept that check?
Pardon?
Is there some reason you didn't want to accept the check as partial payment?
At that point in time, I was not aware that it was for partial payment. It was just a check that was sent by his client, not by the attorney. And we were not aware of what the circumstance was. And that's why I wrote in my letter here, send everything to me, and we'll clarify exactly what happens on the checks. As you'll see from the record on appeal on the various checks that he did send later on, making reference to other things, like a mortgage and like a particular piece of property. I don't trust the defendant. I don't want to deal with him. I don't want him dealing with my client at all. and I would prefer to deal just with the attorney. And this check that was sent out by the client and not through the attorney at all. So we asked that the judge in this case, Judge Antonacci, reviewed all the papers, rendered a decision, and we asked it to be affirmed.
Thank you.
They should not get credit for something that was not cashed and should not have been cashed.
Thank you. 877, Robert Shuttleworth versus Sandra Corey.
Good morning. May it please the court, Brent Seymour on behalf of Sandra Corey, defendant, appellate, and respondent. Here in this case, the court essentially has three things it needs to determine. First is the proper cause of action or legal standard that should apply to this fact pattern, this case, and was that properly pled in the in the complaint and the verified bill of particulars? And then, after deciding what the proper legal standard is and if it was properly pled or will be considered by this court, applying the facts of the case to that legal standard. It is very clear that based on the complaint and the bill of particulars, the only things that have actually been pled on paper are causes of action for negligence, okay? And then we go to cases involving domestic animals or farm animals. Causes of action of negligence are extremely, extremely narrowed, and that is well-settled case law that I don't think we really need to get into today. There's two narrow exceptions. First, you have the Hastings case and the line of cases that follow it, which is essentially the wandering animal cases. In Hastings, the actual, I believe it's a bull or a cow, leaves the property, goes into a road, and there's a car accident, okay? And in all the cases that have followed that, it leaves the property itself.
And so in this case, it didn't leave the property.
It didn't even leave the barn.
But it left its confines to some degree. But you're saying that that's not enough.
That is not enough, and any case that has followed since Hastings has never brought that area in closer. It has always been something that left the actual premise, the plot of land that the owner held.
Well, we don't even know for sure which horse caused the injury, correct?
I think it's been clearly established by the testimony that is the Kashmir Nemesis or Nemi. That was the one who had the interaction with plaintiff. The other exception is the newer line of cases under Hewitt, which is the vet case that they put it back out in the waiting room, and that is a very, very narrow exception that would allow a negligence cause of action. This court, and Judge Bannister, I believe you were on that panel, and Cicero declined to apply the Hewitt exception on negligence in a dog bite case. And that is a very, very narrow exception. Again, this is a vet clinic. They go to school for many, many years, specialized training. I think the dog had been under some sort of anesthesia. There's all these other factors that we just don't have here in our case. And I actually put in Hewitt, because it's only a 2020 Court of Appeals case, into Westlaw just this morning. I think I saw 9 cases, one of which was Cicero, and not a single one of the cases that came up actually applied Hewitt and found in favor of a plaintiff to apply that narrow exception. So no case across the state, no court across the state has actually taken Hewitt, let alone expanded it, but even applied it to another case.
Let me ask you this case, because this case is a little different. I mean, there's evidence in the record that, that the barn or the barn doors or whatever were in disrepair, and the defendant knew it, and that she actually sought rescue, okay? What was happening caused her to say, I need help, come help me. And this, danger invites rescue sort of caught my eye a little bit.
Yeah, and I think there's the List of E. Newton case, which is the 4th Department 2017. And then there's also, it is admittedly a Supreme Court case from Niagara County, Krieger. Those are both on page 14 of my initial brief, where it says that when the injury itself is caused by the animal, the premise liability cause of action does not survive. And that Krieger case, again, understanding it's a trial court decision, was the most factually on-point case of here. That one also involved a horse. A gate was not properly latched. The horse gets out, hits, it was actually an infant plaintiff in that case, and the court said, while you might have been able to create a question of fact on a premise liability cause of action, because the injury was caused by a domestic animal or farm animal, we go to the vicious propensity standard, and sorry, you lose. So moving on to the vicious propensity standard, and again, it goes to this, I think it's the most telling that the plaintiff himself, his testimony admits he didn't have a problem with the studs, he had a problem with the stall. But again, when the animal causes the injury, you can't do the premise liability cause of action, and we go to the more standard strict liability vicious propensity standard. And again, he said he had no problem with this particular horse. There were some arguments made by opposing counsel about this being, a stud, a breeding horse, that then therefore by definition there's an assumption that there is, viciousness, and that is just not that's not applicable under the Bard case and the cases that have followed that. Breeding animals are not by definition considered vicious. It's the same arguments in the dog bite cases that, if it's a pit bull or a Rottweiler, it has to be. The court has not upheld that. There was also some discussion about how other horses had times been rambunctious or the studs could get a little bit unruly, but all of that testimony was more in general about animals on this farm. You have to look at this individual horse, Nemi, and there was no testimony in the record of any specific actions in the past that Nemi had that would lead to the, notice on that issue. And with respect to, lastly, there was an argument that we didn't raise the pleading issues on our initial motion papers. That's just not correct. If you look at, plaintiff's opposition papers and the underlying motion, the record on 206 and 207, he argues that negligence is the proper standard, but then says, well, I'm going to argue vicious propensities as well in the alternative on this motion. So he knew of these, competing cause of action and pleading issues at that time, argued them, but did not take the extra step that would have been appropriate, was to move to amend pleadings that if he wanted to assert multiple theories and separate causes of action, at that time they could have done that. They did not do that, and now they're stuck to what has been pled in their papers, what's in this record on appeal, and the only thing that's been pled are negligence causes of action. Unless the panel has any other questions, I'll otherwise rely on my papers.
Thank you.
Good afternoon, Your Honors. Greg Pajak for the plaintiff Robert Shuttleworth. I want to begin with the pleadings issue, and that's a bit of a red herring here, because all parties at all times were operating under the assumption that the claims here were in both negligence, and we can discuss that in a minute, and then also vicious propensities. We know that because the defendant's own moving papers at page 17 of the record talk about the fact that plaintiff's only claim of strict liability against the defendant cannot survive judgment, and it must be dismissed as a matter of law. So here we have the defense arguing that the plaintiff's claims for vicious propensity must be dismissed. This tells us that they are well aware that those were the claims being made, and if nothing else, by acquiescence, they knew what this case was all about. Their statement of material facts also brings up the fact that they don't believe there's vicious propensities. And then when I cross-moved for summary judgment on this case, because the facts are very unusual, given what the defendant knew and how she invited him for the danger invites rescue that Justice Bannister mentioned, they didn't say in opposition to my motion on vicious propensities, hey, by the way, they never raised this in their pleadings. They simply argued there was no vicious propensities. So the lower court had the defense actually come out and said the pleadings were defective, which they didn't. You can read it, they may imply it a bit, but they didn't come right out and say it. Had they done that, sure, I would have moved to amend, but it was incumbent on them to say something. So now we're in the position where they're saying they said it when they didn't, but now this court can certainly conform the pleadings to the proof because it's clear that they knew this case was about vicious propensities. So let's look at the evidence of the vicious propensities. Here we have a very unusual case where the defendant knew the horses were acting in a dangerous manner to the degree that she said, I feared for my life, I'm not going in there. And now they have the gall to say, we had no idea that these horses could exhibit vicious behavior. That's ridiculous. From the time period that she was aware from inside her house that she heard the ruckus in the barn, she got on the phone, she called my client who was down the road miles away. He drove all the way there. This whole time period, she knew the horses were acting vicious. That's why she wouldn't go in the barn, which is why, frankly, summary judgment should have been granted to my client in this particular case under these very unusual facts. Now, on the negligence side of things, I want to talk about the Hastings case and the wandering cow. And I think the scenario in Hastings, and if you extrapolate that out like I did in my brief, that's why it shows that it's really a standard that doesn't make a lot of sense. Because if this horse had wandered into the road because of the negligently maintained stalls, and my client hit it with his car on the way there, he has a case. But the moment he drives onto the property, and let's say he hit it on the driveway of the farm, or pulling up to the barn, he has no case because now he's on the farm property. That produces a absurd result, but I think Hastings, broadly speaking, refers to wandering animals or escaping animals, and clearly the horse here, or horses, escaped out of their stalls because the defendant didn't properly maintain them. And if there's any other questions, I will rely on my brief. Thank you.
Thank you. 877.1, People versus Truax. Go ahead.
Never quite sure if I should sit down or just go ahead to the podium.
Just go ahead.
All right, I'm going to jump right in. Well, first, my name is Noreen McCarthy. May it please the court, I am here to represent Kerry Truax on his appeal. And I want to thank the court for asking for the grand jury instructions because they were very informative. And I certainly did not have those when I was writing my brief because usually they're not given. And I noticed that for the criminal possession of a weapon charge, the grand jury was told that they could find him guilty if he possesses a loaded firearm and such possession does not take place in such person's home or place of business. Now, there's a lot missing from that. Most importantly, that it had to be an unlawful possession. It's clear that he has a per se constitutional right to possess a weapon outside the home for self-defense, and it only becomes a violation of this statute, even by the terms of the statute, when it is unlawfully possessed. And he might be unlawfully possessed, he might unlawfully possess it because he doesn't have a license, which, as we know, that's a big issue today about what New York's licensing scheme actually is. Or even built into the statute is the exception that it is for self-defense. And in this case, that is a very troubling jury instruction. And I would say even when we got to court and Mr. Truax was entering his plea, what the court asked him was consistent with that. The court asked him, would he admit that you possessed a loaded firearm at the place outside your home or place of business, with no reference to it being an unlawful possession? So we now know in light of Bruin that it is not unlawful to
First of all,
possess.
did he preserve this at all?
I think the fact that...
Doesn't it have to be preserved?
No.
All the cases that we have dealt with that are dealing with Bruin, it's not exempt from the preservation rule, and I don't believe this was preserved.
I think it actually is exempt, and here's why. Because Bruin was decided while this case was on appeal, and Bruin set a new standard. Before that, we only had Heller and McDonald, which talked only about the constitutional right under the Second Amendment to have a weapon inside your home for self-defense. And I think that clearly Bruin, in the upheaval it has caused across the country, established a new rule and a new standard.
Okay, we'll look at that.
Okay.
Thank you.
And I would say I listened to all of the 6 arguments before the Court of Appeals on this issue.
We have that.
Yeah, and they will, we're expecting that to come out this week anyway, so, but I know that is one of the issues. At least the attorneys have told me that's what they're expecting.
Let's go on to your next
Okay,
argument.
so what I would ask this court to do, though, in this regard, is to focus on those 8 seconds. And I think the question, the 8 seconds that are captured by that video. Because aside from that video, which I'm not sure how the quality of yours is, but mine's terrible. Aside from that video, we have 2 eyewitnesses who say they never saw my client with a gun. They don't know who shot. They actually thought it was Williams, and they thought it was my client on the floor who got shot. And from that, what we have from that video, and what we know there was an altercation before that 8-second shot. We know that Williams stabbed Green just before that. We know that there was 6 or 7 guys against my client and his 2 friends. And when we see the beginning of that video, Kerry is running for his life from Williams. He's running for his life from Williams. Williams is chasing him. Williams still has the knife. Another guy is with Williams. My client falls to the ground. He's barricaded by the banister, and he falls to the ground on the 2nd story of this thing. And the 2 guys are kicking him all over his body.
The grand jury saw this, correct?
They saw it 4 times, actually, because they had to keep asking to re-see it because they couldn't tell what was happening. And that's where we get Officer Albertine, who is giving his opinion of what happens on that video. So I would ask this court to look at those 8 seconds and say, because we don't have any evidence of when he might have come into possession of that gun, and I'm assuming he did, but ask in those 8 seconds, didn't he have a right of self-defense during those 8 seconds to possess that gun? And I think the answer is a resounding absolute yes.
Did he have a right to possess it in a law?
Well, I don't think it mattered. That's a public place. And Bruin says you have the right to public carry. It's a public place.
Okay,
so
good.
I'm not sure that we get around that here. Yeah.
And again, he pled guilty, correct?
Oh, he pled guilty, but it's clear from what the court asked him that he wasn't pleading to this charge. He was pleading to something that actually wasn't a crime. It is not a crime unless it is unlawful possession, it is not a crime, and it cannot be a crime under the Constitution to possess a loaded firearm at a place outside your home or business.
Okay, we understand that. Okay, we'll look into all that.
Okay, yeah, so my point is, even if he pled guilty, he did not plead to a crime, and his waiver of appeal was invalid. This court has already looked at the same language.
I don't think there's going to be any.
Right, so no issue on that one, I think. And I do cite a lot of cases on the preservation issue on that. So the second part of this, though, is that it is actually the government's burden to prove that it was unlawful. And this court held that way back, and I think it was 2014, in People versus Holes, which is 11883rd, 1466. This court held that it was the government's burden to prove that he knowingly possessed a gun, which was not part of the jury instructions here, and that it was not innocent possession of the gun. Again, that was not part of the instructions here. So,
Do you have anything further? Because you're almost out of time.
I might, okay. Mr. Truex is sitting in prison for 7 years for exercising his constitutional right protected by the Second Amendment to possess a weapon for self-defense. We would ask that the convictions, both of them, be reversed. We would ask that the sentencing, if the court does not reverse both of them, in light of Bruin and in light of the improper conduct in the grand jury and the improper instructions to the grand jury, that the case either be remanded to determine whether or not he actually he was acting in conformity with his, well, I would say that the government has to prove that he was not acting in self-defense here. And finally, failing all else, we would ask that the court reduce his sentence significantly in its discretion, because it was clearly based on improper representations to the court, as well as the court repeatedly saying, I'm going to sentence you to 7 years because you used that gun, which the grand jury found was justified. And that's why he is sitting in prison for all this time. Okay, thank you.
May it please the court, Elizabeth Dannon for the people. We would submit that the defendant's conviction for criminal possession of a weapon in the second degree was not in violation of the Second Amendment or New York law, and we would do so on the basis that the statutes under which he was convicted were not overturned by Bruin. What Bruin did, the narrow holding, was to hold unconstitutional the proper cause requirement for concealed carry permit in New York, not the licensing scheme that requires an applicant to show that no good cause exists for denial of a handgun license. And to show that, at the beginning of Bruin, the court noted provisions A through N of Penal Law 400.00, subsection 1, that if he wants to carry a firearm outside his home or place of business for self-defense, the applicant must obtain that no good cause exists for the denial of a license. And then it drew a distinction between 400.00 subsection 2F. To secure that license, the applicant must prove that proper cause exists to issue it. And the holding at page 2156 of Bruin, New York's proper cause requirements violates the 14th Amendment in that it prevents law-abiding citizens with ordinary self-defense needs from exercising their right to keep and bear arms.
Counselor, he was in the mall, right? Destiny Mall?
Yes,
And he had the mall has a rule against guns. Is it a local law too, or do you know?
I have looked it up, Your Honor. It does say that there are no firearms allowed in it. I know that the mall is not a sensitive location per se, because I looked into the definition of what a sensitive location for purposes of concealed.
Even though there's a police substation right in the mall. All right, go ahead.
Okay, so yes,
You love the Destiny Mall, don't you?
The people would also note that the defendant was not licensed to own a handgun per the sections of the law that were not overturned by Bruin, 400.001A or A through N. He had he was under New York Penal Law 265.00. He had committed serious offenses.
This was an incident on Black Friday where they had to clear out the mall.
Yes,
correct?
they did. There was a mass panic there,
Right.
and yeah, so, yes.
Anything further?
I guess we would note that the victims in this case, which Bruin takes account of the fact that there are manner of carrying restrictions as well, which deal with terror. And bearing arms in a way that spreads fear or terror among the people, which, to his credit, this defendant noted in a very eloquent speech during the sentencing that he had caused panic and caused mass trauma, and he took accountability for that and said he was sorry for that, and I think we would do him a disservice to negate that acknowledgement on his behalf. Thank you.
Court is in recess.